Gillingham in Kent. In November of 2023, 6 police officers arrive at the door of a 71-year-old man named Julian Foulkes. He is a retired special constable. He served with the same force that has come for him for 10 years. They handcuffed him in his own home. They searched the house for about an hour. Body-worn camera footage obtained later by a newspaper records the officers going through his belongings and remarking on the contents of his bookcase. He owns books by Douglas Murray. He keeps copies of The Spectator. An officer describes the shelf as very Brexity. They examine a shopping list: bleach, tinfoil, gloves, which had been written by his wife, who is a hairdresser. They seize his electronic devices, they take him to a police station, and they hold him in a cell for 8 hours. They interview him under the Malicious Communications Act. At the end of it, he accepts a caution, a formal warning that requires an admission. He accepts it because he is afraid that a continuing investigation will stop him traveling to Australia to see his only daughter. Here's what he did. 2 weeks earlier, a mob in Dagestan had stormed an airport looking for arrivals from Tel Aviv. Foulkes read about it. On the platform then called Twitter, a stranger posted that if the Home Secretary called him an anti-Semite for attending a pro-Palestinian march, he would sue her. Foulkes replied to that stranger. His reply warned that Britain was one step away from people storming Heathrow looking for Jewish arrivals. He says the warning was about anti-Semitism, not for it. Read in plain English, that is what it says. The reply had been seen 26 times. 2 days after he posted it, the Metropolitan Police Intelligence Command referred it to Kent Police as a concern about online conduct. 8 months later, after a national newspaper obtained the footage, Kent Police apologized to Mr. Foulkes, expunged the caution from his record, and opened a review. The police and crime commissioner called what had happened to him unacceptable, and Mr. Foulkes began legal action. He got his apology. Not everyone does. And an apology arrives after the thing it apologizes for. Now, 340 years before, 6 officers went through Julian Foulkes' bookshelf. Other officers went through another man's study in another English town and carried away his papers. Among those papers was a manuscript. It was long, it was unfinished, and it had never been published, and almost nobody alive had read a word of it. That manuscript killed him. Welcome to Consequential Actions Podcast. I am Jeff Kellick, and this is episode 10, part B of Self-Evident, The Road to 1776. On Saturday, we told the story of Algernon Sidney and John Locke, the martyr and the philosopher, and of the manuscript that the Crown pulled out of Sidney's study and used it to take off his head. Today, we take up the rule that made all of that possible. 3 words of Latin delivered from the bench by Lord Chief Justice George Jeffreys. Scribere est agere. To write is to act. 2 things at the front about what this episode is and is not. It is not about incitement. There are cases in which a person writes something that urges violence against real people at a real address, and a government punishes him for it. And reasonable people argue about whether the punishment fit. Those cases are worth arguing about. They are not the subject here, because they are not what happened to Sidney. Sidney wrote a treatise of political theory that no one had read. The strongest version of the incitement objection gets a full hearing later in this episode in what we call the skeptic's case, where that belongs. What this episode is about is the other thing. Political argument containing no call to violence treated as conduct by a state. Private writing pulled into the open and used against the person that wrote it. And the question the historical episode ended on: what happens to liberty when the record of your thinking is permanent, searchable, and held by somebody else? The second thing is to say about the aim. This episode names a British government, a Chinese government, and an American administration. It applies the same standard to all three. I am not interested in which team is holding the instrument. I've spent enough of my life around politics to know that an instrument built by one party gets inherited by the next one, and that everyone who builds one is certain that they will be the last one to hold it. The question this series asks does not care about the party. It asks whether a thing left people more free or more governed. And the third thing, this episode does not end in gloom. One of the regimes we are going to examine has already been rolled back, in the country that had gone the furthest with it, because people argued in public until a government changed its mind. That is the ending, and it is a true one. Let us begin.
Welcome to the Consequential Actions Podcast. Here we ask a simple question of the history and the actions that have shaped our lives.
Did this leave us more free or more governed? Because what we do not know can be used to govern us.
And what we choose to ignore always will.
Let us start with the mechanics. On June 25, 1683, a warrant was issued for Algernon Sidney's arrest in the roundup that followed the discovery of a conspiracy against the life of Charles II. When the officers came, they took his papers. Among the papers was the draft of the book he had been working on for years, a long refutation of Sir Robert Filmer's claim that kings hold an unanswerable title descended from Adam. He was brought to the bar of the Court of King's Bench on November the 7th. That was the arraignment. He asked for a copy of his indictment and was refused, and was sent back to the Tower to wait another fortnight, asking in vain for counsel because English law at the time did not permit a man accused of treason to have any. The trial itself opened on November 21st. He was condemned on the 27th, and he was beheaded on Tower Hill on December the 7th. Now, the law he was tried under, the English statute of treason, required that the offense be proved by the testimony of two witnesses to an overt act. Not one, two. That requirement existed because treason is the charge a government reaches for when it wants a particular man destroyed, and the people who wrote the safeguard understood that a single, well-paid voice is easy to find. The Crown had one witness. His name was William Howard, 3rd Baron Howard of Essex. He had saved his own neck by informing on his friends, and nobody in that courtroom, including the men relying on him, regarded him as an honest man. So the prosecution reached into the study. The shorthand version of what Jeffries did is not quite right, and the accurate version is worse. You will often read that the manuscript was made to serve as the second witness. That is a convenient summary, and it is not what technically occurred. What Jeffries allowed was proof of the discourses and proof that Sidney had written them to stand as evidence of a separate overt act, the act of compassing the king's death. The writing was not slotted into the witness box, it was converted into an act of its own, which is a different maneuver and a more elegant one, because it did not violate the two witness rule so much as walk around it. The protection stayed on the books. It simply stopped protecting anybody. And the instruction that made it work was 3 words. Scribere est agere. To write is to act. The Solicitor General told the court the book was an argument for the people to rise in arms against the king. Sidney's answer to that has outlived almost anything else he said in the room. He replied that if you take Scripture to pieces, you can make blasphemers of all its authors, that you may accuse David of denying God and the apostles of drunkenness by quotation. He was convicted. In 1689, 6 years after they killed him, Parliament reversed his attainder as wrongful and unjust. That reversal is worth noticing. It is an admission by the same institution in writing that the thing had been a judicial murder. But it arrived after the axe. Now cross the ocean and skip a century. The men who wrote the American Constitution knew this case. They knew the whole English law of treason, and what they built was a response to it. Article 3, Section 3 of the United States Constitution does something no other clause of that document does. It defines a crime, and then it makes the crime hard to prove. Treason against the United States, it says, shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of two witnesses to the same overt act or on confession in open court. Let us read the words carefully. Two witnesses to the same overt act. The word same is doing work that the English statute had left undone. It was exactly the gap that Jeffries had walked through, and confession only in open court, which closes the door on a confession extracted somewhere else and produced later. The overt act requirement was written to confine treason to conduct rather than expression. That was the design. The framers had seen what a government does with a man's papers, and they wrote a rule intended to make it impossible to do it again here. In 1945, in Cramer against the United States, the Supreme Court read the clause for the first time in a modern case. Anthony Cramer was a naturalized citizen who had met with two of the German saboteurs put ashore from a submarine on Long Island in 1942. Two witnesses could testify that the meetings happened. They could not testify to what was said or that Cramer had given the saboteurs anything at all. Justice Robert Jackson, writing for a court divided 5-4, held that the overt act proved by two witnesses must be sufficient in its setting to sustain a finding that aid and comfort was actually given. Meetings that were innocent on their face could not be made treasonous by inference from a man's opinions. And Jackson noted in passing that the accused's own out-of-court admissions could not supply what the overt act lacked. That is a strong protection. And I would be overstating a little if I stopped there. Because 2 years later, in Haupt against the United States, the court narrowed it. The two witnesses, the decision held, are required to prove only that the overt act occurred. They are not required to prove the intent behind it, and they are not required to prove that the act was treasonable. Other evidence may supply those. So the clause is narrower in operation than it reads. And there is a practical point. Treason prosecutions have very nearly disappeared from American law, not because the protection worked, but because prosecutors stopped needing to use the charge. The menu of federal offenses expanded enormously across the 20th century, and none of the others carries the two-witness rule or the overt act requirement. A government that wants to punish you for something has other options. So that is where this stage leaves us. The founders looked at what happened to Algernon and Sidney and wrote a specific rule against it. And the rule was real, and the rule covered exactly one crime. They could write Scribere est Agere out of the law of treason. They could not write it out of everything a government might one day decide to do with the things that you have written down. Boreham Wood in Herefordshire on January 29th of last year. Maxie Elland is a radio producer. His partner, Rosalind Levine, is the mother of their 9-year-old daughter, Sasha, who is disabled, neurodivergent, and has epilepsy. Sasha attends Cowley Hill Primary School. The couple had a running dispute with the school. They had questioned the process by which a new head teacher was being appointed. They had criticized the leadership. They had sent a lot of emails. They had said things in the parents' WhatsApp group. The school banned them from the premises, which meant that they could not do daily drop-off, could not attend the parents' evening, could not go to their daughter's Christmas performance, and could not walk in to give teachers medical information about a child with epilepsy. The school went to the police. 6 officers came to the house. They arrested both parents in front of their crying 3-year-old on suspicion of harassment, malicious communications, and causing a nuisance on school property. The couple were fingerprinted and searched and held for 11 hours. The investigation ran 5 weeks. It concluded with no further action. 2 details are the reason this case is in the episode rather than in a list of local grievances. The first is that the offending messages were never disclosed to them. They were arrested over words that nobody would show them. When they went back through the parents' group chat themselves, looking for what could possibly have caused it, they said the strongest thing they could find was Rosalind Levine calling a senior figure at the school a control freak. The second is that a serving county counselor, Michelle Vince, who had contacted the school after several parents raised concerns with her, was subsequently told by police that she too could be accused of harassment. That is an elected representative being warned off relaying complaints from her constituents. Hertfordshire police initially defended the arrests as necessary to investigate the allegations. The force has since admitted that the arrests were unlawful on the specific ground that the legal test for the necessity of an arrest had not been met, and paid the couple £20,000 in damages plus costs. That concession has limits worth naming. It is not an admission that the complaints were invented, or that the investigation could properly have been opened, or that every message in the chat was beyond question. It is an admission that the police did not need to put handcuffs on 2 parents in their own home to find out. Now set that beside 1683 and ask what is actually similar, because the honest answer is narrower than the rhetorical one. Sidney was tried for treason and beheaded. Allen and Levine were arrested, released, cleared, and compensated. But the family resemblance is this. In both cases, criticism of how an institution was being run was redescribed as actionable conduct. And in both cases, the person who wrote the words was not shown precisely what in them justified what was being done to them. Sidney was refused a copy of his indictment. Allen and Levine were refused disclosure of the messages. Julian Foulkes, that we discussed earlier, was arrested under the same act, Malicious Communications, over a reply that had been seen 26 times. He did not stop at the apology. Supported by the Free Speech Union, he brought a claim, and in May of last year, Kent police agreed to pay him £20,000 plus reasonable legal costs in a full and final settlement, and referred itself to the Independent Office for Police Conduct. The chief constable telephoned him personally. And in his case, there is the bookshelf. The footage does not tell us that his library appeared in any formal assessment, and I am not going to claim that it did. What it tells us is that the officer searching a man's home over a tweet stopped to notice what he had read and remarked on it. Douglas Murray, The Spectator. Very Brexity things. It at the least raises the question whether his reading was being treated as relevant to the kind of person they had come for. I think that question answers itself, but the footage is what it is, and you can decide. Britain has recorded since 2014 something over 103,000 things called non-crime hate incidents. That figure and the related figure of more than 9,000 under investigation in 2024 and 2025 come from Freedom of Information returns compiled by newspapers covering a stated number of forces. Thus, they are not a single official national series. The name tells you what these are. They are not crimes. They are police records of an incident someone perceived as motivated by hostility where no offense was committed. What made them dangerous was not the record. It was that the subject often did not know a record existed, and that such a record could surface later in an enhanced criminal record vetting, in an application for a job working with children, for instance. In December of 2021, the Court of Appeal in England held that the recording guidance then enforced unlawfully interfered with freedom of expression because of its chilling effect. The case was brought by a former police officer named Harry Miller over tweets about gender. The court did not hold that every conceivable record of that kind was inherently unlawful. It held that the guidance producing them, as written, went too far. Now the numbers I will not use. You will see it said that British police make 30 arrests a day over offensive posts, which comes to about 12,000 a year. Those figures describe arrests, and arrests are not convictions. In 2024, there were roughly 1,160 prosecutions for malicious communications, and 137 sentences of immediate imprisonment, most of them under 2 months. So if I reach for the biggest number available to make Britain look worse than it is, well, then I would be doing what the government does when it reaches for the worst sounding characterization of what you wrote. No. Now, the Metropolitan Police announced in October of 2025 that it would stop investigating non-crime hate incidents. That decision applied to the Met, not to every force in England and Wales. The government then commissioned the College of Policing and the National Police Chiefs Council to review the guidance, and on March 31st of this year, it accepted every one of their recommendations. The Home Office announcement is headed with the statement that non-crime hate incidents are to be scrapped. And Parliament has since gone further than an announcement. The Crime and Policing Act received royal assent on April 29th, and it repeals the statutory provisions that gave the Home Secretary the power to issue the non-crime hate incident code at all. On commencement of that repeal, that code is automatically revoked, and police forces in England and Wales will no longer operate under a specific statutory framework for recording this material. A new and narrower national recording standard is to replace the one written in 2011. Tied to preventing crime, protecting life and property, and maintaining public order. Incidents meeting the new threshold will not be given a crime reference numbers and will not use words like suspect and victim. The Home Secretary, Shabana Mahmood, said forces would no longer be policing perfectly legal tweets. That is a real change, and it moved in the direction of liberty. This is no longer a proposal. Parliament has enacted the repeal, but an enactment is not the same thing as every force having completed the transition, and we cannot establish that the repealing section has yet been commenced. The replacement framework remains an implementation question. And here's the second thing in that same announcement that anybody cheering it should read. The government also said it is working with the Crown Prosecution Service and the police to ensure robust use of the existing hate crime and public order legislation wherever conduct meets the threshold, and that Lord MacDonald is reviewing that legislation with particular attention to protests and to the stirring up of hatred. The criminal statutes are not going anywhere. What is going is the practice of opening a police record about lawful speech. So the honest version is this. British citizens, British courts, and a British police force, and finally British ministers argued about a policy for years, and that policy is being dismantled. That happened. It is worth knowing that it can happen. It is not a victory lap because the machinery that reached Julian Foulkes was a criminal statute, and that statute is still on the books. Now the other half of Saturday's question. Not what a state does when it finds your writing. What it means that your writing is always able to be found. In the People's Republic of China, there is an offense in Article 293 of the criminal law commonly translated as picking quarrels and provoking trouble. It was drafted as a public order provision, brawling, making a commotion in a public place. In 2013, the Supreme People's Court and the Supreme People's Protectorate jointly issued an interpretation that extended it to online speech. A vague offense about disorder in the street became a vague offense about disorder in the mind of the public. It is a heavily used charge. Chinese legal scholars have criticized it as a pocket crime, one that can be made to hold almost anything. And a research team within the Supreme People's Court has itself warned about its overuse. Now, I cannot correctly, accurately point out the annual totals because the published figures mix persons charged, cases filed, and convictions, and we can't pin down a single official table that means what I need it to mean. What is documented is that the published judgments under that charge largely vanished from the court's own public database. That is a fact about transparency rather than a fact about volume. Nobody outside the system can say how often it is used, which itself is a point worth making. Now one man. In September of 2019, a WeChat user named Zhao Xinzang was detained in Taiwan. He had forwarded a single video clip to a friend in the United States. Not posted, forwarded to one person privately. He was held first in administrative detention, then transferred to criminal detention, and eventually served 10 months. And then the detail that belongs at the center of this episode, according to Gal's own account, given to Radio Free Asia, when he was shown the evidence against him, he realized that the screenshots the police were holding had not come from his phone. He had deleted everything after sending it. Now that account is his, and I'm handing it to you as his. He had done the thing all of us do when we think better of something. It made no difference at all because the record was never his. There's a lazy version of the comparison I'm about to make, and I have no use for it. The United States is not China. Britain is not China. But the difference is not that one side had a constitution, the other does not. China has a written constitution, and Article 35 of it formally promises freedom of speech, of the press, of assembly, of association, of procession, and of demonstration. Similar to what we said in last week's interview with Brendan Kirby about Antonin Scalia's reporting of the Soviet Constitution, the Chinese Constitution has all these protections. It is about how the power uses it. Those words are words on a page. The difference is whether rights can be enforced against the government by a court that the government does not control, whether institutions can bind executive power, and whether the record of what a state did stays public enough for anyone to check. That is the whole distinction. It's not a small one. It is most of everything. The architecture of the record, though, does not care which country it is installed in. And the American version is worth looking at plainly. In fiscal year 2025, United States Customs and Border Protection conducted 55,318 searches of travelers' electronic devices. Roughly 50,900 of those were basic searches. An officer going through a device by hand, which require no suspicion at all. 13,590 of them involved United States citizens, up from 8,657 in 2023. CBP will tell you correctly that this is less than 1/100th of 1% arriving international travelers, and that such searches are used against smuggling, exploitation, and fraud. That is their honest point, and so it should be made. And then on July 13th of this year, the question got an answer. In the United States against Belmonte Cordoza, in the Fourth Circuit, held that a manual search of a traveler's phone at the border is a routine border search, requiring no warrant and no individualized suspicion whatever. Forensic extraction, plugging in a machine and copying the contents, remains a different category and requires some measure of individualized suspicion. But the hand search does not. Look at what that covers. Basic manual searches were about 92% of everything CBP did last year. The ruling is now binding in Maryland, Virginia, West Virginia, North Carolina, and South Carolina, and it puts that circuit alongside others that have reached the question. And look at the case that came out of it. A man arrived at Dulles from Bolivia. An officer asked him to unlock 2 phones. He did. Within 2 minutes, she had opened his photo gallery, including a hidden folder, and found images of the sexual abuse of children. He received 18 years, and the facts could hardly be less sympathetic to the man raising the Fourth Amendment claim. That is the pattern again, and it is worth naming out loud. The hardest imaginable facts arrive first. The rule gets written on them, and then the rule applies to the next 55,000 people whose phones contain their divorce, their medical history, their politics, and their unfinished arguments. As for what happens to what is taken, in 2022, Senator Ron Wyden reported that the data copied from devices at the border was being held on a central database, accessible to roughly 2,700 personnel, retained for as long as 15 years. That was the policy as disclosed in 2022. It concerns extracted data rather than every hand search, and I have not confirmed against any current directive that it stands different. Set that against the one American case that speaks most directly to Sidney's study. In 1969, in Stanley against Georgia, the Supreme Court held that a state could not make it a crime for a man to possess obscene material in his own home. Justice Thurgood Marshall wrote that if the First Amendment means anything, it means that a state has no business telling a man sitting alone in his house what books he may read. That is as close as American law comes to saying what Sidney's case demands. And notice its structure. Stanley protects the room. It does not protect the record, because the record is not in that room. It is on a server in the custody of a company subject to a process you will likely never hear about. Sidney's manuscript was in a drawer in his own house, and the government had to send men to fetch it. That was a real physical limit on how often a government could do such a thing. That limit is now gone. It did not lose a legal argument. It dissolved in the ordinary convenience of how we write everything down, what is stored in the cloud on another company's server. So I've covered the Twitter files before in this series and previous series, and I'm not going to spend this act retracing it. The short version is this. Beginning in late 2022, internal records released by the platform, then called Twitter, documented sustained contact between federal officials and the company about particular accounts and particular posts. What that showed was real. What it did not show was a judgment by any court about whether it was lawful. That distinction is the subject, because the case that was supposed to settle it did not. Missouri and Louisiana, along with the individual plaintiffs, sued. They won a preliminary injunction in the district court. The Fifth Circuit narrowed it and largely affirmed it, and used strong language in doing so. And then on June 26 of 2024, in Murphy against Missouri, the Supreme Court held 6-3 that the plaintiffs lacked standing. Justice Barrett, for the majority, found that they had not traced their injuries to specific government conduct closely enough to sustain the injunction. The majority expressly did not reach the merits. So when someone tells you that a court confirmed the whole story, the accurate answer is that no final merit judgment did. Two lower courts made preliminary findings on a preliminary record. The Supreme Court reversed on standing. That is where it stopped. 4 weeks earlier, though, the same court had decided the other case, and that one states the rule. On May 30th, 2024, in National Rifle Associations against Vullo, the Supreme Court ruled 9-0. In an opinion by Justice Sotomayor, the case came out of New York, where the state's chief financial regulator had pressed insurance companies and banks to cut ties with the NRA. Taking the NRA's allegations as true, which is what a court does at that stage, the court held the complaint stated a First Amendment claim. Government officials may not coerce private parties in order to punish or suppress views the government disfavors. Officials cross the line when their conduct, in context, could reasonably be understood as a threat of adverse government action aimed at suppressing speech. Persuasion remains open to them. Threats do not. Note what that decision is and is not. It is a rule about what counts as coercion. It is not a finding that Ms. Vullo, in fact, did everything alleged. But the rule is the thing, and a unanimous court announced it on behalf of the National Rifle Association. It does not know whose side it is on. That is the point of having it. Then in March of this year, the Missouri case ended in a way almost nobody predicted. The parties settled. And on March 25th, Judge Terry Doherty in the Western District of Louisiana entered a consent decree running 10 years. It binds the Surgeon General, the Centers for Disease Control and Prevention, and the Cybersecurity and Infrastructure Security Agency, CISA. It bars them from threatening social media companies with legal, regulatory, or economic punishment to get protected content removed, and from unilaterally directing or vetoing moderation decisions. That is being described as a landmark, so I read it. What is actually in it follows. Paragraph 25 limits the term social media companies to 5 named platforms: Facebook, Instagram, X, LinkedIn, and YouTube. Paragraph 26 is the one nobody quotes. The prohibition, it says, is limited to the plaintiff's social media content and does not extend to content posted by non-parties. And the plaintiffs are directed to hand the enjoined agencies a list of their social media accounts so that the agencies know which accounts they are required to leave alone. Read that again. The protection runs to the named plaintiffs, not to you, not to me. Paragraph 28 limits what the court can do about a violation to ordering the offending statement removed or retracted and declaring it null and void. Paragraph 17 says the agreement is not to be construed as an admission of any issue of law or fact. And 2 of the original plaintiffs had by then withdrawn from the case because they had been appointed to run agencies that were defendants in it. So it is real an enforceable legal instrument and establishes no adjudicated constitutional violation, protects a named group rather than the public, reaches 5 companies, and can be enforced only by the parties and, for states, only by 2 attorneys general. I'm not telling you to take anything away from the people who brought that case. I am telling you because a settlement is being read as a verdict, and because a movement that reads on its own press releases instead of its own documents will eventually get caught doing it. Now, the last thing is the closest thing in modern American law to what happened to Algernon Sidney. In 2024, a doctoral student at Tufts University named Rumesa Ozturk, I hope I'm pronouncing that right, Rumesa Ozturk, co-authored an opinion piece in the student newspaper. It criticized the university's response to student resolutions about Gaza and called on Tufts to disclose and divest certain investments. A year later, in March of 2025, her visa was revoked. Days after that, she was detained on a street in Somerville and by plainclothes federal officers and moved through multiple states to a detention facility in Louisiana, where she was held for more than 6 weeks. The government's own paperwork says this. A State Department memoranda records that the department had not produced evidence that Ozturk engaged in anti-Semitic activity or made public statements supporting a terrorist organization, and concluded that the particular foreign policy ground was not sufficient. A separate memoranda records that the revocation was approved anyway, under a different discretionary authority. In May of 2025, ordering her released, District Judge William Sessions said that on the record before him, the government had introduced no evidence other than the op-ed and found that she had raised a substantial claim of a constitutional violation. In February of this year, an immigration judge terminated the removal proceedings, finding the government had no basis to deport her. The government appealed to the Board of Immigration Appeals, and in April, the parties settled the whole thing: the immigration case, the challenge to the termination of her student record, and the habeas petition. She had completed her doctorate in February, and she went home to Turkey. Homeland Security statement said it was glad to see her leave and that a student visa is a privilege and not a right. One legal distinction matters here. Revoking a visa is not the same act as extinguishing a person's lawful status inside the country. A visa is a travel and admission document. And on this point, the government put something in writing. In a letter dated March 30th of this year, an assistant United States attorney acknowledged that Ozturk was in a lawful non-immigrant status when Homeland Security terminated her student record. So she was here lawfully. The State Department's own memoranda found no evidence sufficient for the foreign policy ground it examined. When Judge Sessions considered her detention, the government introduced nothing beyond the op-ed. An immigration judge later terminated the removal case. The government appealed that, and the remaining litigation ended in settlement. And the charge is not the one the people expect me to make. This is not an invention of this administration. Discretionary authority over who may enter and remain is old, and administrations of both parties have used it to exclude people for what they believed and said going back a very long way, nor is it a power that operates unreviewed. The review happened, and she won it. The problem is the order of operations. She was arrested, moved 1,000 miles, and held for 6 weeks first, and the legality was sorted out afterwards. The power, whose first exercise can outrun its own review and impose the punishment before anyone decides it was lawful, is not a lesser version of the power Jeffrey used. It is that power with the sentence served in advance. Now, 2 accountings are owed here. We all have watched people whose views we find repellent lose their accounts, lose their platforms, get shouted down or shut out. And maybe some of us have felt a small satisfaction about it. Not every time, but maybe some of the time, and more often than we would like to admit in public. And that satisfaction was not because we had carefully thought about whether the action was legitimate. It was because we did not like them and something bad happened to them. Schadenfreude. That reaction is the engine of the whole problem. Nothing in these cases requires us to assume the people using the power understood themselves as tyrants. The school that called the police believed the criticism was cruel and the staff were suffering. The officer who noticed the bookshelf was very likely trying to work out what kind of man he was dealing with. Most people exercising a power like this understand themselves to be protecting somebody. The check on that is not good intentions. The check is a rule that binds you when the person you are aiming at is somebody you cannot stand. Second, impressions. We all have them. We know that we are not always even-handed. British speech policing has been an enormous topic in libertarian and broadly right-leaning media for 2 years, and rightly so. The Foulkes case and the Boreham Wood case became known because people made noise about them, and that noise contributed to a policy actually being dismantled. Now, that is a real accomplishment, and we should not take it away from anyone. But the Ozturk case did not get the same energy from the same quarters. And I do not think the reason is complicated. She is a foreign national, and she wrote something controversial. And it's about a topic that most people are still struggling to understand fully. The same asymmetry in the response runs the other direction too. A great many people who did speak with real force about the Ozturk case had nothing to say about the coordination between federal officials and platforms back in 2021. And a great many of people who were outraged by those platform censorships have gone quiet since March, when the settlement they celebrated turned out to protect the list of named plaintiffs on 5 websites. So if you're concerned about the state reaching into private expression, rises and falls on whether you like the person being reached for, what you have is not a principle, it is a preference. Now, 3 objections. The first objection. You have chosen easy cases and avoided the hard one. The critic says this: you build an hour out of a school WhatsApp group and a retired constable's tweet, and you left out the case that actually defines British speech law right now. On July 29th, 2024, the day 3 children were murdered at a dance class in Southport, a woman named Lucy Connolly posted on X. She called for mass deportation, and she urged that hotels housing asylum seekers be set on fire. The post was seen 310,000 times and reposted more than 900 times before she deleted it 3.5 hours later. She pleaded guilty to publishing written material intended to stir up racial hatred. She was sentenced to 31 months. In May of 2025, the Court of Appeal refused her application, holding the sentence was not manifestly excessive. The objection says, this is what these laws are for. A country was on fire. Buildings with people asleep in them were being attacked. If your principle means that a woman walks, your principle is not serious. Concede the whole of it. That is the hard case. And my principle does not mean that she walks. A call to set fire to a building with people inside it belongs in a different moral and legal category from calling a school administrator a control freak. Britain punished it under its statutory prohibition on material intended to stir up racial hatred. Now, I cannot tell you American law would reach the same result. Under the standard the Supreme Court set in Brandenburg, advocacy may be punished as incitement only where it is directed at producing imminent lawless action and it is likely to produce it. That is a different test from the British one, with different elements. Wide circulation during a period of disorder does not automatically satisfy it. Whether an American prosecutor could have won that case is a genuinely open question, and let's not pretend we know the answer in this segment. The second reply is the whole point of this hour, and it needs restating carefully. Connolly and the Boreham Wood parents were dealt with under different provisions by different mechanisms, with different outcomes. So the honest version of the charge is institutional rather than statutory. Hard cases are what expansive speech policing powers get built on and defended with. Once those powers exist, and once a culture of using them exists inside a police force, they migrate into disputes that look nothing like the cases used to justify them. That is not a claim that one statute did both jobs. It is a claim about what happens to instruments after they are made. Now, the second objection. Britain never had a First Amendment, and you are judging it by a document it never adopted. Straightforwardly correct, and it needs stated properly. The United Kingdom has no single codified constitution and no First Amendment. It has a long tradition of balancing expression against public order, and it has made those choices democratically, through Parliament, over decades. An American cannot invoke the First Amendment as though it governed British law. Conceded, sure. But the standard in this episode is not the First Amendment. It is the question this series always puts, which is about delegated power. And it does not depend on any nation-specific text. And notice who's been making the case in Britain. It was the English Court of Appeal that found the recording guidance unlawful on British grounds under British law, which Britain does have. It was the Metropolitan Police that stopped investigating. It was a British Review and a British Home Secretary that began dismantling the system this March. It was Hertfordshire's own force that conceded the arrest was unlawful and then paid. And Kent's that apologized and then paid. The criticism is not imported. Britain made it in British institutions, and Britain acted upon it. The third objection: writings are ordinary evidence, and a visa is not a right. Okay, this is the sharpest one. Every criminal justice system on earth uses what a defendant wrote as evidence of what he intended. The search history, the text message, the note in the drawer, that is not thought policing. It is how intent is proved. And a system that could not do it could not convict anyone of any offense requiring a state of mind. And separately, a visa is a discretionary document extended to a foreign national. The political branches hold broad authority over admission and removal, and the courts give it wide berth. Nothing that happened to Rumesa Ozturk resembles a treason trial. All of that is true, and the second half is real law. And the objection is missing a third possibility, which is one that I'm actually defending. Words are sometimes evidence of conduct that happened somewhere else. Words are sometimes themselves the wrong, a threat, a fraud, a solicitation, an agreement to commit a crime, perjury. And words are sometimes lawful political opinion, and that a government has decided to treat as an act because it does not like the opinion. The first is legitimate. The second is legitimate provided the offense is properly defined and the state of mind is proved. The third is Jeffries. Apply that to this case. There was no independent act the op-ed was helping to prove. The government's own memorandum says so. Nobody has ever identified a legal wrong inside the op-ed itself. Not a threat, not solicitation, not fraud. What was left was the opinion. That is the third category. The visa point does not save it. It changes the remedy available and the forum. And it explains why she was detained rather than indicted. It does not supply the missing offense. And now the liberty test. The question the series always asks, did this leave people more free or more governed? And the way we get at it, fancy hats and larger mobs. Government has no powers except those its peoples could have handed to it, because no one can delegate an authority you never possessed. So take the thing being done, put it in your own hands, and ask whether you could do it. And if you could not, ask whether 1,000 of you could. Could you alone take the neighbor out of his house in handcuffs because he criticized your school's hiring in a group chat? Obviously not. That is kidnapping. So could 1,000 of you, 1,000 kidnappers? Well, 1,000 kidnappers is a mob. It's not an authority. Could you go into a man's home and read his bookshelf to work out whether his opinions are acceptable? No. Could 1,000 of you? No. And now the honest limit, because the test does not run explicitly clean on this subject. There is a real power here that individuals do not hold. Governments can compel evidence. They can subpoena records, search on a warrant, put a witness under oath. I cannot do those things, and neither can 1,000 of me. And yet, almost nobody thinks that courts should be unable to. Run strictly, the delegation argument proves too much. It would abolish compulsory processes along with everything objectionable, and right now I am not arguing that. So, 2 more concessions. Writings generally are evidence. And no serious person wants a jury kept from a murderer's search history. And the delegation principle is a moral premise about where authority comes from. It is not a rule that a court will apply. It tells you what to think about power. It does not by itself tell you where the edge of that power sits. So the test does not locate this line for me. I have to locate it and then defend it. I put it in 3 parts rather than 1 because 1 was not enough. A writing can be evidence of conduct that happened somewhere else. That is ordinary, and every free country does it. A writing can sometimes be the wrong itself, the threat, the fraud, the solicitation, the perjury, the agreement. The law may reach those, provided it names the wrong and proves the intent. But a government may not take lawful political opinion and convert it into a punishable act merely because the opinion was written down. It has to identify a real legal wrong inside the communication or an independent act the writing helps to prove. When it can do neither, when the file says there is nothing else and the offense is that the argument was made, that is Scribere est Agere, with the Latin taken out. So run the episode through it. Algernon Sidney? Well, that was more governed. There was no second witness, and a manuscript was converted into a deed to supply what the law required. Borehamwood? More governed. The force itself has conceded that the arrests were unlawful and paid damages. The border and the record and the database is too more governed, and mostly without anybody deciding to make it so. That one arrived by convenience rather than by design, which is why so little stands against it. Rumesa Ozturk, also more governed. A writing was produced as the act by a government whose own memorandum said it had nothing else against the persons its own lawyers later confirmed was here lawfully. And the dismantling of the non-crime hate incident system. Well, this is more free. Not the system. The system was the thing worth criticizing. The reform is the liberty. And it came because British people spent years arguing in public that their country was becoming less free, and a court agreed, and a police force retreated, and a government changed the rule. Which is worth setting against Sidney's own case, because his argument did win. Parliament annulled his attainder in 1689, 6 years after he was beheaded. The Discourses was published in 1698 and became part of the political inheritance that crossed an ocean and turned up in the arguments of men who never met him. He wrote in private for no audience at all, and the fullest constitutional fruit of it ripened long after he was dead and far from where he was buried. You and I do not have to wait that long. That is the difference between his position and ours, and it is more than most people spend on it. This Thursday, we close the week with a conversation. It takes up the question this episode leaves open. I will be joined by Dr. Thomas Lane, the county attorney in Greene County, Iowa, the first libertarian elected to a partisan office in that state, a former professor of constitutional law and political philosophy, and a candidate this November for the United States Senate. He taught these texts for a living before he ever charged anybody with anything, and he's the only guest we could have had for this particular week. Somebody has to draw the line I just drew. In 1683, a judge drew it, and it was ratified by a jury that Sidney himself charged had been packed against him. And a man died for a book. Locke's answer to that was when a government exceeds the power its peoples could have delegated, the trust dissolves. But he did not locate the remedy in any individual's certainty about his own righteousness. He located it in the judgment of a people as a body, after a long train of abuses, and finally in what he called an appeal to heaven, which is to say, beyond any earthly umpire at all, which leaves the practical question standing, and it is a hard one. Who decides that the trust has been broken before force decides it? Thomas Lane has an answer involving a jury's power to refuse, and it is a startling thing to hear from a prosecutor because he could be on the losing end of it on any day of his working life. I intend to press him on it, and I hope you will join us. I am Jeff Kellick, and this has been Episode 10, Part B, of Self-Evident, The Road to 1776 on the Consequential Actions Podcast. If you have enjoyed this episode and want to follow the series, please subscribe to our Substack page at consequentialactions.com. Here you'll find all written articles, as well as our previous series on the General Welfare Clause, the New Leviathan, and Empire of Liberty. Subscribe to our YouTube channel at Consequential Actions Podcast for video versions of all podcast episodes, and follow me on X at @JKellick for updates, discussions, and announcements. We continue to post articles and welcome your participation. Thank you for watching, and until next time, have a great day.